Resuscitation.
Missing somebody? Seems
Resuscitation,
we
to
have more
revive
room here
someone.
than we usually do.
Revive someone from the dead.
All right.
A drowned
Добрий день,
swimmer
пане
to
Романе.
resuscitate him.
Good afternoon, Roman. Good afternoon.
Чуєте, все добре?
Can you see and hear us? Is everything fine? Yes.
Так мені здається, що якась затримка є.
It seems to me there is a delay in the signal, but we will sort it out as we go. Roman, welcome to stage 2 of the selection for HQCJ.
З вами проводиться конкурсною комісією.
The interview will be conducted by all members of our selection commission: Yevhen Mezentsev, me, Ivan Mishchenko, Ted Zajechny, Robert Brugheisen, Stephen Markman, and Sergei Verlanov. The rapporteurs for your interview are Yevhen Mezentsev and Ted Zajechny.
Якщо з якихось причин
Should for any reasons our interview be interrupted, I mean lack of internet connection, a blackout, air raid alert, we will stop our interview and we will resume it on a different day and at a different time.
бесіди прохання відповідати.
Throughout the interview, you are kindly asked to be brief and precise when answering our questions. A commissioner asking you their question has the right to limit the time for your answer.
Власне, співбесіди вам
Before we start the interview, you will be given the floor for introductory remarks to tell us more about your motivation, to tell us about the ideas about the work of the new HQCJ and the judiciary in general. With that, I'm passing the floor to my colleagues, Yevhen and Tad. You're welcome. Thank you, Mr. Chair. Good afternoon, Roman. My last name is Mezentsev. Today I'm going to be the lead rapporteur during your interview. So, if I may, I will introduce you briefly and then we'll pass the floor to you for your self-presentation. So, from the outset, I have to say that I have all of the virtues of our candidate listed on several pages. Usually, it doesn't take that much space. So, Roman Kuibida was born in 1980. His experience of working in the field of law is 19 years. He studied at the Kyiv National University of Taras Shevchenko, and he has a PhD in law. Roman is quite a well-versed person, somebody who is known in the legal community. He was a member of PIC. And at that time, there was a conflict between HQCJ and PIC when HQCJ admitted people with regards to whom there were negative opinions from PIC, and there was a legal debate at the time with regards to this conflict. Roman participated in the development of a number of laws dedicated to judiciary and the status of judges, in particular the law itself, the law on judiciary and the status of judges. He prepared some amendments to the Criminal Procedure Code of Ukraine, the Code of Administrative Justice, and the In 2019, he was a member of the Commission on Legal Reform, and since 2019, he's been the co-founder of De Jure NGO, one of the most famous civil society organizations which controls and monitors the activities of the Ukrainian judiciary. He is a member of the Commission for the Selection of Staff for the Specialized Anti-Corruption Prosecutor's Office, and he was trying to speed up the decision on the appointment of the Specialized Anti-Corruption Prosecutor, and for that reason he had a conflict with the head of the Commission. The PhD thesis of Mr. Kuibida has to do with the organization and development of a modern judiciary, so it's as relevant as possible for what we are currently doing. With that in mind, Mr. Roman, since 2007 and 2017, has been involved in education. He's been working with the National School of Judges. He's the associate professor at the Taras Shevchenko Kyiv National University, and he also lectures at the Kyiv-Mohyla National Academy. He has a number of scholarly publications. At the moment, he serves in the Armed Forces of Ukraine. And with regards to his property status, according to the information that we've received from NABU, there are no concerns with regards to his income and assets. There are no corruption risks. He does have an apartment in the city of Kyiv. There is an object of incomplete construction with the area of almost 43 square meters. Plus, Mr. Kuibida owns a Citroen Berlingo manufactured in 2013. He bought it for 190,000 hryvnias, which accounted for $25,000 at a time, which is quite a reasonable price for this car. The income of Mr. Kuibida over the past 24 years is almost 6 million hryvnias. So this was my short introduction on behalf of the Commission, and now we are passing the floor to you. You will have between 3 and 4 minutes for this self-introduction. Thank you very much. Thank you for the invitation to the interview. Thank you for this introduction. It should be mentioned that justice is something that I'm interested in. So this is my main calling. So if we are discussing justice and justice in the work of the judiciary, then I can say that I was developing some proposals, some things that could be implemented. I am sorry, Roman, sorry for interrupting you. Unfortunately, we cannot hear you well enough. Could you please sit closer to your mic, if that is possible? When you're closer to your mic, somehow the quality of the sound is better. If that's possible, could you please sit closer to the microphone? Thank you for paying attention to this. So let me continue. So for a number of years, I've been working on some proposals. That is why I believe that we need not only to develop some proposals, but also to think of ways of how to implement them. So, as I told you, justice is something that I'm really passionate about. I think I'm a good member of a team. I know how to work in a team, and I know how to achieve some results. In view of the fact that the judiciary reform remains incomplete, I would like to be involved in the procedures that will result in its completion, the implementation of standard and values that I share with my colleagues. I think that, my colleagues from the Center of Political and Legal Reforms. When you are an outsider and you see how many things go wrong, of course, it disappoints you. That is why I decided to apply for this selection, and I prepared my documents back in February. Thank you, that is clear. While introducing you, I had this impression that a person with a kind of your background and experience, you are the ones who's supposed to be asking us questions, not the other way around. But the rules are all the same for all of the participants, and I would now like to start asking you our questions. So, Roman, in your opinion, what indicators, could you please name at least 2 or 3 indicators that we could use to assess integrity and moral values of a future judge? The Public Integrity Council has been using 6 indicators. These indicators include impartiality, independence, competence, fairness, and others. So these are all the values that the society expects to see in the work of judges. That is why I would not narrow down the issue of integrity to impartiality, to somebody being honest and not taking bribes. It's not just about corruption. I think integrity is a much wider concept than anti-corruption is. That's clear. Thank you. During previous interviews, we discussed the new anti-corruption strategy, which I hope will be adopted for the year 2023-2025. And it foresees the strengthening of the role of PIC in the procedures of selection. In this context, how do you think? Do we need to review our procedures towards the selection of PIC members? Not the structure of PIC, but the selection of PIC members. Do we need to maybe enhance the level of trust? Or would you leave the approaches that we currently have unchanged? Frankly speaking, I would follow the existing approach because at the moment, members of PIC are not some organizations that were created the day before yesterday. So the requirements that we already have for civil society organizations are quite high in order to become a member of PIC. Excuse me, so you believe that these requirements are sufficient as of now? As far as the requirements for civil society organizations, then yes, and I'm really happy that members of PIC are not just lawyers. I do believe that we have too many lawyers on PIC, but we can also have human rights advocates there who are not lawyers. We can have journalists on PIC. So this gives us an opportunity to have this wider perspective on the activities of judges and generally on the things that exist in the judiciary, both positive and negative. Thank you. Roman, it's not about this selection, but in some other situations that were discussed in open, you talked about a conflict that you had with Mr. Maselko, current member of High Council of Justice. Let's assume that you're appointed an HQCJ member. In what way do you believe it will be possible for you to eliminate this conflict of interest? I don't think we have a conflict of interest because our mentality is quite similar. We do share values. I'm not talking about a conflict as a conflict, but a conflict of interest. Yes, I reported about the conflict of interest on one occasion. So, a person who participated in the selection was using the services of Mr. Maselko as a lawyer, and at that time I was also using his services because he was representing my interests at HQCJ when we were having the case of complaint with regards to a Supreme Court judge. So I reported about this kind of connection that I had to Mr. Maselko, but since he is no longer my lawyer, he is no longer my representative, I never recused myself in this connection. But I did notify about these circumstances because a person from outside may say that there is a conflict of interest because I wanted to prove my impartiality. But I think that with me disclosing this information, I was able to prevent any kinds of allegations. Thank you. Do you know about any foreign practices in the selection of judges? And if you do know, would you like to borrow from some of those practices? Would you like to borrow from the best examples? I do believe that we are currently borrowing from some of the experience of foreign countries. We are doing it by having a more careful selection of judges. I think that it's warranted for countries like ours, We have left behind the political mechanisms in the selection of judges. That is why I think that as far as the appointment of judges is concerned, we are on par with the majority of European countries. But as far as the mechanism for selection of judges existing in other countries like the United States, for example, I think that these mechanisms would not be very efficient for us. Perhaps only on the level of so-called justices of peace. Thank you, that's clear. In your quite successful legal career, where you have some significant accomplishments, what achievement would you consider to be the most important? What achievement are you most proud of? And do the two coincide? Your greatest achievement and the one that you are most proud of? Thank you very much for this question. I've never thought about it. I think I should not be the one to give any assessments of my achievements. Let the other people do that. But I'm happy that people are using the instrument such as registry of court decisions so that people have access to court judgments and court decisions. So I was involved in the development of the law on access to court judgments. And also the mechanism of public involvement in the procedures of assessment of judges. My contribution is there, but again, I wasn't the one making this contribution. I was doing that a part as a team, so I cannot say that I was the only one who did that. Thank you.
Thank you. Good afternoon, Mr. Kuibida. I take some interest.
Good afternoon.
I take some interest in your role in founding de jure, and I wonder if you could explain briefly your motivation for doing so and the level of cooperation that exists between de jure and the other civil society organizations.
Thank you for this question. With regards to de jure, yes, indeed, I was one of the co-founders. At the moment, I'm in no way involved in their activities. I used to be a board member, but as far as the motivation behind the creation of de jure is concerned, at the time I was working at the Center for Political and Legal Reforms, and I couldn't see myself outside of that organization because we really had a great team. But I understood that the sphere of justice required more involvement on the part of the civil society. And the more people we could draw into the reform process if we had versatile civil society organizations. It would mean that our judiciary would be transforming much faster, meeting the expectations of the public. That is why I think I can even be proud about my involvement in founding of this organization. But I am no longer involved in their current activities. As an outsider, I just watch what they are doing.
Yes, thank you. I was curious about that. However, let's turn more of our attention to the High Qualification Commission for judges and some of the ideas that you have in that regard. You say in your motivation letter, Mr. Kuibida, that I am ready to undertake in order to meet public expectations of one of the most important reforms that remains unimplemented. But you do not further develop that idea. Can you tell me what specific important reform that remains unimplemented you were referring to here?
There are many reforms that have not yet been completed in Ukraine, which can probably make the courts more convenient for the users of judicial services. But I meant the requirements for integrity, because we have the demand on the part of the society. That is something that has not been completed. So the key authorities that can influence these processes are HQCJ and HCJ, but I guess HQCJ to a greater degree can help with this because it does select judges, and High Council of Judges is involved with some disciplinary action. So as far as the selection and the completion of qualification assessment are concerned, so that is the mandate of HQCJ. And I think that the more representatives of the public we have on this body, not just judges, even though it is prescribed by the legislation that there should be 8 members who are judges, but I think that the tasks and functions of HQCJ in this way could be accomplished.
Yes, thank you. I expect that you have studied the law that brings into creation our selection commission. And there is much discussion, of course, in this area, and we are very concerned with the issue of integrity of candidates for appointment to the HQCJ. And I expect that you have studied Article 95, paragraph 21, which sets out the integrity criteria that we are directed to consider and assess. For my part, I consider that to be a very comprehensive list of the integrity criteria. And I would be interested in hearing your comments about how those criteria are described in Article 95:21. Does that accord with your views of the criteria for integrity?
Well, I've already told you that I see integrity as a much wider concept, but even though I have studied the law and the description that we have in the legislation is quite comprehensive, we have these Bangalore principles in place. So in the legislation, I think that the interpretation is quite narrow, the interpretation of the integrity criteria. Well, we can talk about different aspects or different facets, maybe if you'd like me to be more specific.
Let me just read it to you. High Qualification Commission of Judges of Ukraine membership shall be deemed to meet integrity criteria if he's independent, honest, impartial, incorruptible, industrial, adheres to ethical standards, demonstrates impeccable behavior in professional activities and private life, if there are no doubts regarding legality of their assets, conformity of he and his family members' living standards and reported incomes, conformity of the candidate's lifestyle and his status. What else could possibly be included in the criteria of integrity?
I think that it's also about being diligent. Because you can meet all the other criteria, but you be a lazy person and not do the job that you've been entrusted with.
Well, yes.
So it's about being diligent about your duties. I also think it's part of the integrity concept.
Yes. The law uses another word, which I think was intended to mean the same thing. It's an industrious. Now, that is the English translation. The reason I ask you this is because this, of course, is the standard that our selection commission needs to apply in assessing the integrity of candidates for the HQCJ. But it occurs to me that much thought was put into these criteria, and these criteria could also be valuable to be applied to the work of the HQCJ in assessing candidates for judicial appointment or promotion. Do you agree?
Yes, I agree with you. For the new HQCJ, as for the previous HQCJ, being industrious or hardworking is really important. It is important that everybody is willing and eager to work in view of that great scope of workload that this body is faced with. And from my own experience of being a member of PIC, I can tell you that some of PIC members who became the actual members had no idea as to what they were supposed to do. They had no idea about the great workload. Unfortunately, we didn't have that many members like that, but in the process of work, they somehow left us. So that is why it is very important that all the candidates for HQCJ also realize what the great workload, how great the workload is.
I couldn't agree with you more, Mr. Kuibida, on that point. We have discussed with a number of candidates the very large workload and any ideas they may have to cope with the workload. And I may return to that, but there is another area that I'm very interested in, and that is the relationship between the PIC as and when it should be appointed again and the HQCJ. No one will know better than a member of the PIC the difficulties that were encountered between the PIC and the HQCJ, and the relationship which ultimately was terminated because the PIC concluded that the HQCJ did not properly respect the PIC advice and opinions. Now, with that background, one of the ideas that has been advanced is that there should be a regular committee that is created between appointed members of the HQCJ and the PIC that would meet weekly, review the agenda, review the timetable for the interview and assessment of candidates, and also discuss and perhaps agree on the sharing, mutual sharing of information in a timely fashion. Now, would you support such an idea?
I would definitely support this idea, and I can even tell you more that the better the interaction between the two bodies, the better the result is going to be. I think that the problem of the previous HQCJ and previous PIC was that in terms of values, they were different because the public definitely urged for the integrity criteria to be followed, and the HQCJ was quite closed in their activities. Here I'm not talking about the interviews that were broadcast on YouTube, but we could often see that the decisions that they made did not coincide with what the PIC thought, with the materials that the PIC provided. So some of the decisions made by HQCJ were surprising, and it was a mental conflict, a conflict of different mentalities. And I think that the selection for HQCJ that we are currently having will help us overcome this conflict of mentalities. Definitely there should be interaction, some meetings, not just a regular committee. Yes, we did have some meetings between some members of HQCJ and PIC when we were developing the indicators of conduct that lacks integrity. I think that at the time we did have some interaction, but unfortunately those indicators were not later adopted by HQCJ, the indicators that we developed together. So I think it should be about a shared platform, about shared values, which will make the work of both bodies more efficient. Of course, all people are different, there will be discussions. We cannot do without it. But let me share some positive example from the work of PIC. When we first met, we didn't know each other, but the first thing that we discussed was the values that we shared. And I think that is something that can be a uniting factor in the work of PIC and HQCJ, because the end goal should be the same for the two.
Thank you for your answer. I'm coming to the end of my questions, but you raise a point that I think has not been raised that I have seen by anyone else. You actually, if I understand what you have said, if the translation is accurate, you actually recommend a three-party meeting, a meeting between the PIC, the HQCJ, and the HCJ to discuss some of the very same things that you have just commented upon. Can you comment on that suggestion, please? I think it is a novel suggestion that I have not heard before.
I didn't talk about three parties. It was just HQCJ and PIC, but I definitely think that HCJ should also be involved in such discussions. And the criteria that PIC has developed can be this shared product. And all the three bodies in their activities may use these criteria. I'm talking about the criteria of conduct that lacks integrity, so that the activities of all the three bodies are predictable, regardless of whether we are talking about selection, qualification assessment, or disciplinary action against a judge.
Last question. Do you think the members of the PIC should be paid by the government for their work as PIC members?
My personal opinion is no, but it was a huge issue for us in view of the great scope of work that we had to do, and for many people it was unmanageable because they still needed to have some odd jobs to earn some money. Of course, it was very helpful to have the secretariat where people got their remuneration, and the secretariat helped prepare the materials for assessment. That was really helpful during the final stages in the activities of PIC, but prior to that, we only needed to have people motivated, people whose motivation is to have the result, not some remuneration. Maybe my colleagues will not like what I'm telling you now, my former colleagues from PIC, but indeed they suffered from this great workload and lack of opportunity to maintain their families. So there were members on PIC who would maybe wanted to get some salary. I think that is something that can be discussed, but I personally never demanded any salary, understanding the importance of the work, and I saw my membership in PIC as voluntary work.
Yes. Well, if you think that the PIC had a lot of work in the past, I think it will be small by comparison to the work that they will have for the next 4 years. And there's been a suggestion that perhaps there should be a recognition of salary and that it be administered by the state judicial administration. But I take it you're not in support of that idea.
No.
All right. Thank you.
Окей,
Євген?
thank you. Будь ласка, Сергію, ваша черга.
Serhiy, you're welcome. Good afternoon, Serhiy. My name is Serhiy Varlanov. In continuation of the topic of the activities of HQCJ, let me ask you this question. In your opinion, what were the mistakes made by the previous HQCJ? And how do you see solutions should you be appointed as an HQCJ member? Solutions to those past mistakes. Thank you for the question. It's a very interesting question. I think that the HQCJ developed a rather good methodology.
Ключова проблема була
But the key problem was that regardless of the principles and rules, everything depends on the people who are implementing
питання
or
розглядати
enforcing them.
конфліктом інтересів.
So some of the issues involved conflict of interest.
Ваша робота
I think that your work as a selection commission is already a certain solution for some of the problems of the previous HQCJ. The second thing that I'd like to draw your attention to is that we need to have more transparency in the work of HQCJ, because some of the scores were really unmotivated and it was not clear neither for the judges nor for outsiders where the scores came from. That is why we need to have a very clear motivation in the scoring and the decision. So if there is a practical assignment, it means that this assignment must be published. We shouldn't be afraid of the low quality of the assignments, that it may cast shadow on the judge or the candidate judge.
Практичного завдання є
But
здійснюється в екстремальних певних
we do realize that practical tasks are performed under some circumstances of stress. We cannot demand that they are all perfect, but I do believe that we can publish these practical assignments.
Мабуть, проблема не в методології.
I think it's not about the methodology, which in my opinion is quite good. But we need to think about making all of the procedures more transparent so that the outsiders can really have an idea as to how this methodology is implemented. Thank you. Thank you. That is clear. My next question. In your motivational letter, you say that you were involved as a national and international expert by different projects, Council of Europe, OSCE, the European Union, etc. And you mentioned that most recently you were studying the mechanisms of public participation in the judiciary reform. So what specific mechanisms have you studied? And are these mechanisms used in Ukraine?
Цих механізмів досить багато.
We have a variety of such mechanisms. Some of them have to do with some interaction, with some kind of support for those receiving judicial services,
Я маю на увазі
something that will make the judicial procedures simpler. And I'm talking about some leaflets, for instance, which can explain the structure of the judiciary. We can even have this kind of map, this kind of route for regular citizens, telling them where they need to go to get a specific judicial services. So if there is also an issue, people, the public can be involved in development of some legislation, in lobbying of some of the provisions, and their further adoption or implementation. For instance, I focused on legislative novelties.
достатньо для того, щоб досягнути позитивного результату. На жаль,
And
воно не спрацьовує.
unfortunately, not always it does work. I mean, with this involvement of the public, it's not always reflected in laws what the civil society may suggest to the lawmakers, but that's one facet in which the civil society can be involved. We can also talk about the involvement of the public in qualification assessment, in the selection. We can talk about the role of journalists who collect some information. It can be done. For instance, we have some information about one particular judge who is problematic, But it doesn't always mean that the problem applies to this particular judge alone. It may be evidence of some systemic issues within the judiciary. Of course,
Досить, я вважаю,
the PIC, I believe,
інструмент,
is an important tool of public participation in the judiciary reform. That's clear. Thank you, Roman. I'm passing the floor to Judge Markman.
Thank you very much. Professor Kuibida, thank you for your participation. We appreciate it. Your reputation is such, Professor, that I think we must take seriously what you say. Words, I believe, are meaningful to you as an academician, as a man of a public service. You say in your motivation that your methodology has become more supportive of what you call the visionary approach and less supportive of the evolutionary approach. First of all, can you tell me what that means as a practical matter? Are those words, or is that a real redefinition of what your thinking is about the judicial reform?
Дякую за те, що ви звернули увагу на цей момент.
Well, thank you for paying attention to this point in my motivation letter.
Можливо, тут пояснив би
Let me probably explain it as follows. We need to set very high goals, very high objectives, very high bar, and start reaching them gradually. Maybe I could give the example by analogy with Elon Musk and sending people to Mars to prevent overpopulation of the Earth. So step by step, he's moving in this direction.
я думаю, що тут так
And I think that this is what we should take into account. We should have the vision of the court of the future, and step by step, and probably there will be some small steps and some large steps that we should take to reach this understanding, this vision. For example, I think that quite a lot of workload of judges could be
електронних систем.
done by different electronic systems, including some AI-based systems. For example, the issue of reconciliation of the parties could be done in that way. People could be excluded from that job as mediators, and in many cases you can be using different tools in this area that help people communicate and that help them reach the results that will be good for both parties. Also, I think that we could apply the same in the work of courts when machines could be helpful. They could be used. I mean, AI-based tools could be used to, let's say, prepare some analytical data in the case, and in some minor cases even reach the stage of court decisions. And there could be a lot of small steps like that. The main thing is to have in your mind a strategy or a vision of what court we would like to have in the future, and then we could think about the steps taking which we could reach this vision. Because normally in our reform, we are trying to find the problem and trying to repair this problem, to find the remedy. And this is also a good way, and I don't mean that we should exclude this method. No, it has its own advantages, but I tend to think that we should also see the vision, the objective, and move towards it.
Have we been deficient or derelict in trying to inquire of candidates what their vision is? Most every candidate gives a general vision in which they talk about elevating the judiciary to European and international standards, the attainment of the rule of law, a transparent judiciary, a fair judiciary. What are we missing in that process? Is there something that we're not doing as well as we should? Are we not emphasizing a vision too? Are we not trying to elicit a vision too from the candidates?
Я прошу пробачення, на жаль, немає можливості стежувати.
Well, I'm sorry. Unfortunately, I was not watching the interviews because I don't have an opportunity to be watching the interviews. So I cannot tell what is wrong about this. I think that generally it's very good that you ask the questions about visions and values and the rule of law, justice, transparency. These are all values.
Я би не сказав, що це візія.
I would probably not characterize it as the vision of how this could be structured, how the process could be structured. These are rather values. But there may be different systems, and all these systems may be helpful in reaching a vision. Some of them may be worse in that, the other ones will be better in that. For example, if we take the Bangalore principles, these are the values that tend to unite people. But what do we want to reach? I mean, the very functioning of the system and what issues the system should be considering, what issues probably should be excluded. That's already the vision. For example, some minor cases always used to be considered by courts, but now some categories of cases, some types of cases are settled electronically, like fines, parking fines, and things like that.
We want judicial reform to be a success, of course. Everybody wants it to be a success. One of the things that can potentially stand in the way of judicial reform, though, is to have a commission of 16 people develop as many groups of 16 people do into different factions and coalitions. This is the conservative faction, that's the liberal faction. This is the reform faction, this is the evolutionary faction. This is that faction, this is the other faction. Debate is good, but if you're trying to have a team go in a particular direction as quickly as possible, successfully as possible, you do want to kind of limit some of the factionalism that tends to develop whenever you have 16 smart people together, don't you?
Я, можливо, спробую трошечки пояснити краще.
Well, let me try to explain my idea a little bit better. I think that the Public Integrity Council is not a separate tool. I think that even if the High Qualifications Commissions, after it performs its tasks, may evolutionize into some other body, now we are working you are working at a certain element, at the establishment of a certain element which is aimed at the achievement of improvements in the field of integrity among judges.
But I'm trying to understand, do we want, I'm sorry, I didn't mean to interrupt you, but do we want to have a common vision? How important is it to have 16 people or 32 people recommended who have a common vision, and to have that number of people who have different emphases and different priorities? It's hard to find 16 people who share a common vision on a thing as important as this. But what is your guidance to us in trying to put together a team of candidates? Do we ask common questions? Do we look for common themes? Or are we satisfied when there's a general lowest common denominator of agreement, lowest fundamental level of agreement? We're all on the side of reform. Well, we favor this. One side favors a little bit different reform from the other side. What is going to make this commission as effective as it possibly can? What can we do in this interview process and in this interrogation process to make sure that if you're placed upon this commission, you've got a team that's going to work with you, and you're going to work with the team, and you're all going in the same direction, and you're comrades in arms, just as you are right now on your other team?
Well, I'm not sure that I can really give any recommendations to the selection commission, but I think that you don't need to be looking for people who are like-minded absolutely in everything. Everyone in each of us has some suggestions and some ideas of his own. And that's very good, because it is in the discussion that the best result will be born. But it's important that the people have the same values, that these commissioners of the HQCJ have the same values, confess the same values. And the way they see the implementation and the way they are going to be reaching those objectives, well, here we could have different opinions. But these different opinions are really important. They really matter. Because after the discussion, we will be able, or the commissioners will be able to choose the best option.
Well, thank you very much. I appreciate it, Professor. Thank you. Let me move to my colleague, Mr. Broekhuizen.
Mr. Kuibida, yeah, I've been listening, of course, carefully to what all you have been saying. And I will share you my first thought. When I look at you, without any, not trying to say anything nasty, I see someone from civil society background who has used quite some time in his life to stand on the side of the judiciary from the outside, to yell inside to the judiciary, you're not performing well, you are corrupt, you have to do better. Why are you taking those decisions? They are wrong. That has been your job for quite some time, and you have been paid to do that by outsiders, often USA, Matra, even the Netherlands have been paying, you have been part of those things. If I say this to you, what do you say? It is strange that I have this idea that you're this outsider yelling inside and say to the insiders, you're wrong, you have to change, you have to do differently. We know what you have to do, you don't do well. Or don't you, am I wrong in saying this?
Дякую за таке сприйняття. Я думаю, що
Well, anyway, thank you for your idea, for your perception. I think that there is a grain of truth in that. That's true. Even the lion's share, not the grain of truth, because I myself consider to be representative of the civil society even now. I think that the state and the judiciary work for the people, for the society. Of course, I'm not the voice of the society. No way. But some scientific vision, yes, I probably have this vision of a researcher and at the same time a civil society activist. But I would say that it's more of a researcher who is trying to give assessment of certain phenomena and problems. And in most cases, my work was related to phenomena and not to specific personalities, specific judges, let's say. Well, of course, sometimes I am watching the activity of civil society organizations who rather tend to work with personalities, with special people, and which are trying to disclose some information on special officials, on specific officials. And this is also an important aspect of civil society organizations' activity, but I was more prone to work with the issues of phenomena, of problems and challenges. So more like a researcher. And I was thinking how to stop a certain phenomena, how to improve something. That was the major direction of my work and my mind. That's why largely your perception of me is true, but I cannot agree that somebody just paid to me, for example, for criticizing some court decisions or something like that. I think that even if I criticize some court decisions in some cases, that was only from a certain point of view, from a certain angle. For example, I indicated in my CV that by some chance I became a specialist in the freedom of assembly willy-nilly. It just really happened because I worked with the judicial reform and we had to select some cases that could be the indicator of the changes of the judiciary after the reform. as far as cases and the limitations in the freedom of assembly in Ukraine, because sometimes in Ukraine, well, that was the rule that peaceful assemblies could be restricted in Ukraine only if you went to court. But we were trying to take the cases, in particular the cases of the European Court of Human Rights, and these cases showed that our reform of 2010 in the period of Mr. Yanukovych's rule led to even larger dependence of courts, and courts started being used as a tool for fighting this freedom of assembly, for prohibiting assemblies, peaceful gatherings.
I will be the last to say that judicial reform is not necessary in Ukraine, but that's not what I'm aiming at. What I'm aiming at is that if you go on saying from the outside to the inside that the inside is no good, that the people inside, they will not like you. I've been a prosecutor, as you know, and at a certain moment I was asked by young lawyers what I didn't like when I was a prosecutor. And I said I didn't like to be in court and to be explained time after time that I'm a crook and I'm horrible and I'm terrible and I'm lying. Because even though I'm a state official, I used to be a state official, I'm also a human. And as a human, I don't like to be told time after time that I'm no good, I'm a bad prosecutor, bad judge, etc. And your job has been for quite some time to tell judges that their system, and also it means they are no good. And my question is, should you put such a guy in a commission who should select better judges?
I've got a very good experience of interaction with judges, I would say. I got this experience during different trainings, so I wouldn't say that I have any conflicts with the judiciary and with any specific judges, and that I really criticize them. Well, again, let me stress it again, that there are some phenomena that need to be eradicated from the Ukrainian judiciary. And again, quite often these phenomena are often characteristic not just of the judiciary, it's all also about the interaction between judges, lawyers, prosecutors. So these are some informal practices we should definitely pay attention to and eradicate. So again,
I don't discuss it, that's not what I say. What I say is, I agree that it should happen, but should it be you?
Well, of course, it's your decision whether it's going to be me or not. But even if you don't elect me, but I know that you will be able to develop the composition of the HQCJ that will act in synergy. It's not easy, I understand your task, because you need to have 50% of judges and 50% of other categories. And of course, you will find it difficult. The task is really a complex one. And the selection commission has to select the people who really will be able to interact and not to quarrel with each other.
No, I asked your view about this. Of course, we will make a decision as good as we can, and you're a very extremely good candidate. But the question, the outsider looking inside, saying to the rest inside, you're bad, it gives strain, and it makes the people inside don't like you. It's just normal behavior of human beings, I guess. And maybe I can extend the question, because I will read to you from your motivation letter. Since 2020, I have been a member of the Selection Commission for administrative positions in the Specialized Anti-Corruption Prosecutor's Office, SACPO. And then you say, the work of the Commission aimed at selection of the new administration of SACPO was too long for no valid grounds. It was performed in a condition of mental disputes, polarization of members, and obviously political influences. And this is exactly what I'm looking at. I can imagine if you put people together, one from the left corner, one from the right corner, one from the floor, and one from the top building, that you will have those strains and emotion, mental disputes and polarization, won't you? And this is apparently what happened here. Maybe you can give your view on that.
Я думаю, що зважаючи на спосіб формування...
I think that if we take into account the procedure for the selection of the HQCJ, that will not happen. At least I think that there will be no polarization because you're having a very scrutinizing procedure for the establishment of the commission and for the selection. But the way of work of the commission you've been talking about, in my case, that was really a different procedure. It was a political process. It was the parliament, the Verkhovna Rada, that selected most of the most of the commissioners. And mainly these were the representatives of the prosecutor's office. It was really difficult to work under such conditions because we could see the external observers could see what kind of breaks we had in the work of the selection commission. We couldn't agree. But at the same time, I can tell that I'm satisfied with the result of the work of this commission, though it was a really long-lasting procedure. A lot of time was just wasted. But the result was anyway achieved. A good result was achieved.
Let's say you're elected as a member of the HQCJ, and let's say you're going to have interviews with judges. Yes? That's potential judges. What would you do if it is listed that you will have an interview with a certain judge-to-be, and civil society comes along and says, but this candidate, he's really bad?
Well, if the civil society just provides information in a way of disclosure, it's okay. But if I see that the candidate actually refutes all those claims and I don't see this information as confirmed, because civil society organizations may not have full, complete and exhaustive information. So in this case, I think I can pass the well-grounded decision in spite of the initial assessment of the candidate by the society. But it's also important to make this procedure as transparent as possible.
Yeah, yes, of course transparent, but also independent. That's my point. In our commission, and I find that very strange coming from a different country, we talk to candidates every day, and the day if I open up the Facebook, I can see all kinds of remarks on the internet about candidates we are going to interview, which I find clearly a sign that someone tries to influence me. And personally, I don't like that because I'm appointed to be independent. And I don't want to be influenced the day that I talk to some candidate. What is your view about that?
Well, I often feel myself a spring. The more there is pressure, the more I resist.
Me too.
And pressure always causes resistance.
Yes.
Of course, somebody wants to get the result through this pressure, but if we speak about making information public, this is not pressure yet. This is just what gives you some signal for inspection, examination, or questions. So that's okay.
But it is a difficult position because you are in the commission if you are elected. You are discussing there with judges you may have your view about. You are subject to influences from the outside. You have those relations with donors who have been talking to you for quite some time. And I don't know, but I would see you, let's say, from the views of civil society, but also from the views from the donors as someone who is easily accessible and also it's possible to give you information or to go to you to influence you in order that you take the decision that the outside world wants you to take. That's my point. You may be someone where the outside world thinks, well, he's easy accessible. Let's go to him because we want to avoid something. You understand that, don't you?
Я думаю, що розумію. Можна сказати так, що
Yes,
у мене
I
можуть
understand all
бути
this,
судді, так
but
само.
I'm easy to read for judges as well because I've had to communicate with judges on many occasions, and I have a lot of, well, not connections, but acquaintances among judges. And of course, don't treat the word connections in the negative sense. I would probably say I've heard a lot of communication with the representatives of the judiciary as well, because of course, these are not friendly connections that could really affect my decisions. They cannot come up to me and say, support this one or support this candidate. No.
І це інформація.
They can just reach me in terms of communication of information. And whether this information comes from the judiciary or it has been passed to me through some other sources, if I can verify it, I will take it into account. But if this is just some kind of bullying or intimidation of some candidates, because this may also happen, and I've had cases like this in the activity of the Public Integrity Council. So again, it's all about communication with judges, the representatives of civil society organizations, attorneys at law, and other people. And I don't think that this is a major barrier, major dependence on either the judiciary or the civil society organizations.
Найважливіше те, що є тут.
The most important thing is what you've got in your mind and not what somebody is telling you.
Steve has a question.
Well, I just wanted to say that Ukraine's a free country. The people have a right to speak out. They have a right to share information. You have a right to pay attention to that information if you think it's worthwhile, or to reject the information if you don't think it's worthwhile. I don't think you should be defensive about a debate and a discussion and information going back and forth. That's a healthy thing. It's not a hurtful thing. Thank you.
Well, apparently my colleague takes offense of my questions, but the only thing I wanted to do, candidate, is that I wanted to discuss those issues with you, because I think that they're issues that need to be discussed. Because of course, I don't know all the issues of Ukraine, and you know them much better than I do. But it's what I see, and that's what also the basis of my questions. Back to the
Mr. Chairman.
Thank you. Пане Романе,
So, Roman,
нарешті і до мене.
finally it's my turn.
Рік тому мій друг
A year ago, my friend Dmytro Gadomsky wrote an article entitled
Маселко у ВРП – це кінець.
Maselko in High Council of Justice is the end to activism. And the article is saying that he refers to some other activist from Czechoslovakia, Václav Bent, who expressed a very simple opinion, which says that if state institutions cannot cope with their functions and performance of their functions, the society starts creating alternative institutions. And sooner or later, these alternative institutions created by the civil society
Вони не мають іншого виходу,
will have no other choice but to somehow fit into those state institutions, into their system, because their goal has been achieved. Mr. Kuibida in the HQCJ, if this happens, is it the end of activism or not? Yeah, that's the end of activism. I think that I have not been that much active. No, I mean, not end of your activism. I mean, generally, and is it the end of activism? Well, of course, this is the civil servant's job, public service. And this would not be about using the tools of civic influence. That will be put an end to, and I would not feel myself to be the agent of any civil society organizations in the High Qualifications Commission of Ukraine. The same as Maselko. didn't feel like that in the High Council of Justice. I think so. I cannot speak for him. I don't think that he is the face of the civil society. He is the face of the High Council of Justice, of this updated, restored High Council of Justice. So it's really important to work towards the common result.
Ви разом зі своїми колегами
Together with your colleagues from the civil society, you have achieved
дійсно стала
the situation when integrity has really become the core criterion for selection
судовій системі.
in the judiciary.
Раніше цього дійсно не було.
It was not the case before.
І уявімо,
And let's imagine that
ментального конфлікту між
mental conflict between the members of the HQCJ and civil society will not happen. There will be no mental conflict between them, and the newly established HQCJ will really be holding examinations as assessment of judicial candidates and incumbent judges following the integrity criteria. Why do we need the Public Integrity Council then? Well, you're asking the right questions, and I think that with time, the need for the Public Integrity Council will not be there. But now, the Public Integrity Council has been performing the role of collector of information. It has been collecting important information that could not be collected by the High Qualifications Commission because of some lack of resources. So I think that with time, gradually, even the High Qualification Commission will be exhausted in terms of its mandate because there will be no need for qualification assessment as the reattestation procedure. Of course, after it performs all the tasks, after it really updates the judicial stuff of the judiciary. It's like fire extinguishers who exist not just to extinguish fires, but not to have any fires at all. Well, yes, it's kind of that, for no fires to happen in the future. So in case the role and the mandate of the HQCJ is a success, is successfully performed, I'm sure that the European standards will then function and will keep functioning in the Ukrainian judiciary, and there will be no further need for the engagement of Integrity Council or some other civil society organizations, the same as engagement of foreigners, internationals in the selection commission, because I also consider it to be a temporary interim phenomena which is aimed at achievement of the best result possible now, until the system starts functioning properly. Roman, you are well acquainted with the results of surveys. And I often ask this question because the most recent sociological survey we have is dated August last year. Courts and the judiciary in general take the last but one place in the ranking of trust. The least trusted are only political parties. This is the data from the last year. The reform has been going on for quite a period of time, and you're one of its active participants. What is wrong with this reform? What is wrong are probably the leaders of the reform. I mean, those who were supposed to implement the reform, the High Qualifications Commission and the High Council of Justice. If they had really implemented this, if they had really used all the foundations laid down in the Constitution, the situation would have been different. But unfortunately, they failed to. They failed to use this capacity, and they have, I would say, wasted it. And that's the reason for the failure. So I think that the change in the approaches to the establishment of these bodies will be a major step leading to changes. And the leaders of this reform will have to work towards the implementation of the reform and not try to resist the reform. Okay, thank you.
Any more questions?
I have. Дивіться, пане Романе, в мене не таке
Roman,
буде, звичайно,
of course, my question is not going to be that global as Mr. Chairman's question, a little bit
але мене воно
less global, but I'm no less interested in your opinion as the opinion of the expert on that point, because you have been dealing with the judicial reform and the judiciary almost all your life long. So if we take the people who are candidates for judges, judicial candidates, not incumbent judges who are undergoing a qualification assessment or who are undergoing some disciplinary proceedings, but the people who want to become judges. What could be the constructive way of selecting judicial candidates that you would choose? The negative one, the one that presupposes complete and open examination of information from any sources and preparation of as negative a conclusion as possible in order to determine the level of integrity and professional competence of the would-be judge, or a positive one, a positive approach, or a positive finalizing document that would express the information about the virtues of a person, and that would indicate that, right, this person is a decent candidate, complies with certain criteria, and there may be some negative points, but these points are left beyond. But if these negative features are really overwhelming and prevailing, and do not allow a person to further participate in the competition, well, there will be handshaking, and normally they say, we will give you a call, and this telephone call never comes. So what approach would you suggest? What approach do you like more? Negative one, but with high profile, tarnishing of reputation, or a positive one with positive opinion, but that would, on the other hand, enable to engage a larger number of candidates, or maybe some blended mixed solution. Thank you for the question. I think that any competition, any selection is about selecting the best. And handshaking with those who have not passed the competition is the best way to say goodbye to them. On saying that you are good, but there are some candidates who are better. And I think that during selection of judges, this approach may be applied. And it should be applied. And negative opinions of the Public Integrity Council as a certain tarnishing, element of tarnishing of the reputation, as a certain label would not be the best approach. But, you know, it has played some historic mission when the public could say that this sort of behavior is unacceptable. That was good. Yes, in a certain sense. Okay, clear. Thank you, Roman. And normally, we give the floor to all our candidates at the interview to say their concluding speech. And within this concluding speech, you should either tell what you would like to inform the selection commission about, but maybe we didn't ask the question about that, or just express any opinions and make any remarks you would like to conclude with. Up to 2-3 minutes. Thank you. I will not speak more, speak a lot. Let me express my gratitude to you for the questions. I've really got some pleasure from the questions which you asked, even they were tough, because they made me think, and I'm sure that I will keep thinking about some of your questions even after the end of the interview. Thanks a lot. I've really derived a lot of pleasure from communicating with you. Good. So let me give the floor to Mr. Mishchenko, the chairperson of the commission. Well, the floor has been given to me just to say goodbye to you. That is the end of our interview. Thank you for your participation. Good luck, stay safe, and goodbye. Goodbye. Thank you. Good luck.